profession, and I commend it to the House. Thank you.
I call the Honourable Member Dennis O'Rourke.
Thank you, Mr Speaker. The Lawyers and Conveyancers Amendment Bill Part 1 is about elitism, anti-competitive advantage and historical claptrap. It should in fact be entitled the Lawyers and Conveyancers Elitist Purposes Bill, I think. It takes us back to the days when QCs were appointed by a mysterious, non-transparent process. It re-establishes suspicion of inappropriate influences and political interference, all too often in fact justified. New Zealand First therefore opposes the legislation, at least as far as Part 1 is concerned, and therefore the whole. We don't think it is good for the legal profession in practice, and especially not for its reputation. It's not good for the community understanding of the profession. It is about the National Party's philosophy and ideology, and it is a giant leap back to the past. New Zealand would be moving backwards with this legislation when all comparable jurisdictions have moved on with modern and relevant approaches to the issue of acknowledging senior practitioners. And you only have to look at Canada and most of these states of Australia to see that. Now, it is actually questionable whether it is really even necessary at all to award either Queen's Counsel or Senior Counsel, and we don't see it done for the medical profession, and we don't see it done for the teaching profession, we don't see it done for other professions. These days, markets must be free of discriminatory and anti-competitive impositions, and that includes the legal profession. For some reason, they think they should stand outside that principle. I don't see any reason for doing so. Strangely, National usually supports that sort of approach, so this is a bit of an aberration for them, I think. National has simply got it wrong, and it's got it wrong for the wrong reasons. It's wedded to the past, and it is not future-oriented. However, if we are to persist with the ranking of legal practitioners in this way, rather than to rely on reputation and market, as it should, then it is an important matter to define those members of the profession who have achieved a level of experience and competence, that is, and competence, not incompetence, in an area of expertise which should be officially acknowledged on a fair and transparent basis. The current legislation actually goes a long way to achieve this and should not be undone by this retrograde bill. The acknowledgement of highly regarded and experienced practitioners with special expertise must not be about status or reward or cronyism in the way that it has all too often been in the past. And it should not be seen in the same way as the award of knighthoods and honours. New Zealand is no longer a British colony with all of its traditions and peculiarities. We should not create commercial advantage by one practitioner over another in the way that this bill will do. The New Zealand system must fulfil our needs and be relevant, useful and fair in the selection process and be transparent. This bill does not appear to be designed to do any of that. In fact, it will have exactly the opposite effect. It appears to be designed to perpetuate elitism as distinct from meritism. And by that I mean the recognition of status well earned instead of one simply awarded in the manner of some sort of honour, or worse still, as some sort of favour. Under Part 1, the term Queen's Counsel would return to replace Senior Counsel, and that is unwise. The public can more readily understand the term Senior Counsel, but I don't think it has ever understood the term Queen's Counsel. And understandability is important for the reputation of the profession. People used to think that the term Queen's Counsel meant a senior barrister who had some sort of function supporting the Attorney-General. Of course, that has not been the case for a very, very long time. So Senior Counsel is more descriptive and does not have the connotations of an overhang from the old English system and our colonial past. New Zealand needs a thoroughly modern legal system, and it needs to be seen as such. None of this is assisted by the term Queen's Counsel, and Senior Counsel is much better. Nor does the assertion that somehow the reversion to Queen's Counsel for barristers' sole will enhance the independence of the bar have any merit at all. If independence means independence from the Crown, it really in New Zealand means independence from the government. So this bill is more likely to do the opposite by restoring the old system under which the scope for political and other inappropriate influences is actually worse. Concerning eligibility, it is not clear at all why only barristers sole are favoured to be eligible for appointment as QCs. It's not a good basis in principle or practice for this to happen. Other senior expert practitioners should not be excluded, whether they practice in law firms or not. And we should not exclude barristers and solicitors. And when you consider the huge differences between how barristers and solicitors operate in New Zealand as compared with the UK, it seems anachronistic that we should have this overhang from the UK in the New Zealand system. But the worst aspect, I think, of the bill is section 11A(2), which overrides the other sections in the bill where the royal prerogative is to be reinstated. This is comprehensive nonsense, and yes, it is the cronyism clause. There is no substantive reason given for this huge leap backwards. It's exactly the kind of provision we should avoid. The royal prerogative in New Zealand really means the government prerogative, and all of the disadvantages mentioned earlier of unfairness, discrimination, anti-competitive behaviour, the scope for cronyism and bad process will be entrenched by that particular provision. It is thoroughly objectionable. The need for transparency has also not been achieved in this bill. It's not what modern best practice requires. These days, people rightly insist on a transparent selection process. This will still be a closeted government process in which the public can have no confidence at all. New Zealand First therefore objects to the entire concept of this retrograde bill as it is set out in Part 1. It is misconceived, it's a step back to the bad old ways, it's a barrier to the development of a modern legal system, it's devoid of proper process, it is unnecessarily restrictive, and it is based on discrimination for absolutely no good reason whatsoever. Mr. Speaker, the object should be to define senior practitioners in specialist areas so that the public and other members of the profession are assisted in knowing to whom they may best go for specialist services. Now, if that is not the objective, then there is no reason at all for either QCs or senior counsel to be appointed. For all these reasons, Mr. Speaker, New Zealand First will definitely vote against this very bad bill because of the provisions that are set out in Part 1 for all the reasons that I have mentioned.
Mr. Speaker.
I call the Honourable Member Katrina Shanks.
Mr. Speaker, it's my pleasure to take a call on this